All right, good morning, everyone. We are going to get started. I'm Adrienne Morawski, your Cook County Government Affairs Director, or GAD. I've worked on the RTLO since it was first introduced in July of last year. We wanted to have this session so you have an opportunity to learn more and build confidence as the new law goes into effect on June 1st. Before the programming, I would like to cover a few housekeeping items. As a participant in today's webinar, this is a reminder you will be required to abide by the Illinois Realtors Code of Conduct. A link has been added below for your review. Please use the Q&A button located at the bottom of the screen for all questions. We ask that you limit this feature to only questions and not commentary. We have Betsy Urbance, Illinois Realtors General Counsel, and Mike Scobie, Illinois Realtors Director of Local Advocacy, responding to your questions. We have two panelists, Matt Rentschler with the Illinois Realtors legal team, and Chris Pezza, a realtor and property manager in Chicago, where he has worked under similar provisions. We have some invited guests. We have guests from the county board. They are here to listen to the discussion today. We have two commissioners and their staff. Commissioner Bridget Degnan spent countless hours reviewing and making recommended changes to the RTLO. Thank you, Commissioner Degnan, for being here with us today, and Commissioner Scott Britton. He was the lead sponsor of the RTLO. Although realtors were opposed to the RTLO, Commissioner Britton is here to listen to the discussion. He did not have to be here today, knowing our opposition, so we appreciate it. With that, I invite Commissioner Britton to say a few words.
Thank you, Adrienne, and thank you for having me. The one thing I wanted to point out is the genesis of this RTLO came through personal experiences that I have with a particularly large landlord in unincorporated Cook County in Glenview. That landlord has actually now gone out of business and the bank took over that property, but there were huge problems there. And when I heard from the tenants of that particular facility, I said they should just reference their local landlord tenant ordinance, and then I found out there wasn't one. And there hasn't been one in suburban Cook County since 1986 when the city ordinance was enacted. So I want to make sure that I make it as clear as I can that it was not my intention for this to be a punitive action against the many good landlords who work in suburban Cook County and own properties there. One thing, it didn't come out very much, but in my law practice, I represent landlords in tort cases. I know how difficult the business particularly has been recently. I have many friends who live in the northern suburbs who own rental properties. So my purpose was only to address bad actors and to try to put some kind of synergy between the county rules and regulations and those that have existed in the city of Chicago for 35 years. So I just want to thank Adrienne particularly for participating in this process. It was not always an easy one, but it started in July of 2020 and we passed it in 2021. The reason was, honestly, I think I had the votes to pass it originally, but I wanted to make this as palatable, and I know it's a relatively innocuous word, but I didn't want it to make, I wanted to make as many changes as I could to make this worthwhile, at least as much worthwhile as it can be for those who own properties and rent them out to tenants. And so we made, I think, over 40 changes. I don't know how many hours we spent. There were many emails that went to my co-commissioners, which they just loved me for. But I think it made a difference because we then took a look at some of the things that don't work in the city ordinance and tried to address them in the county ordinance. I'm not asking you to be enthusiastic about this. I understand why you're not. But I do want you to understand that, at least from my perspective, this was meant as a way to assist in weeding out the bad actors in suburban Cook, and that most of the people on this call, perhaps all, are never going to do the things that I saw personally in a very large apartment complex in suburban Cook. So that is the basis of why we did everything we did. We changed some things to make it less onerous than the city ordinance, particularly the right to cure provisions, which Adrienne was very active in making sure we passed. And I've done everything we can over the last few months to begin an education process. There is a website that talks about the RTLO. We have had multiple listening sessions, including with the Chicago Bar Association, where I spoke to a number of lawyers about what the provisions of the new ordinance are and judges who will be interpreting it. And then lastly, the county has instituted substantial rental assistance. The most recent American Rescue Plan also has substantial resources, which I am trying to use in my district in the north and northwest suburbs to help pay rent, to keep people in their homes, which was the purposes of the RTLO, but also to make sure landlords can get the money they're owed and that they can also continue to pay their mortgages and their kids' college tuition and everything that goes with that business. So I'm here to listen, to answer whatever questions I can. I am not giving any legal opinions on the ordinance itself. I can just tell you from a sponsor, and I thank again Commissioner Degnan, who helped make this a much better ordinance by getting rid of some of the unwieldy language that's still in the Chicago ordinance. But I'm here to listen, to answer whatever questions I can. Thanks, Adrian.
Thank you, Commissioner Britton. We appreciate you being here today to hear, what the feedback is that we are getting and some of the questions. So I am going to share my screen. Before we get into the roundtable discussion, I would like to provide just a really high level overview of what realtors or what you should look at when you're considering RTLO and learning more about it. So give me just a moment while I share my screen. All right, so with the RTLO, I want to give you an overview. Of course, before we get into the roundtable discussion, as we've talked about, the RTLO was first introduced in July of 2020. We spent the fall, we spent even the beginning of this year in the middle of negotiations, countless hours, a lot of time with commissioner, a lot of time with the commissioners. And so we were able to get some amendments. Some of the amendments include 6 units or fewer owner-occupied buildings. We have a lease non-renewal notice shortened. You may be used to that 30-day month-to-month lease, but a non-renewal notice is now 60 days as opposed to 90. There's also the right to cure provisions for landlords if there is a clerical error while processing the security deposit. And also the tenant must notify the landlord of their right to cure if for some reason there was a mistake. A lot of these amendments were as a result of our call for action. Thank you so much if you participated in a call for action. There were 2. Usually we don't have 2 call for actions, but we were really pushing. And so again, just thank you for participating in that call for action. The effective date is June 1st. So that's just about a week away. And so knowing that this is the effective date, about a month ago, we prepared the Illinois Realtors Resource Guide just to help understand what's in this new law and to help you with some guidance as you try to implement and comply with the county's RTLO. So what are the things that you need to know? 1, what is the municipality of the property location? 2, what are the prohibited provisions within a lease? 3, what are the required disclosures? And 4, what are operational changes that you need to be aware of as a landlord? All right, so municipalities. If you live in a particular municipality that already regulated the landlord-tenant relationship, your municipality may be exempt from the county's ordinance. Chicago, Evanston, Mount Prospect, those are all exempt. Oak Park is in discussion of adopting their own version. Prohibited provisions. These are just 2 examples, but there is a list. Late rent payments are limited, so there is a cap. It's $10 for the first $1,000 in rent, then 5% for any rental amount above $1,000. So again, there is that late rent cap. And then there's also the move-in fees are allowed, but the cost must be associated with the move. So there in the guidance document, there is a list of possible items that move-in fees are associated with, but there must be something that is associated with the move. It can't just be a fee that has nothing to do with the move. And required disclosures. There are at least 10 disclosures that we've identified as required by the RTLO. The landlord exemption. If for some reason the landlord or the owner is exempt, that 2 to 6 unit owner occupancy, there's a required disclosure. Also, there's a utility cost disclosure. Is it the landlord responsibility or the tenant responsibility to pay the gas, electric, those sorts of things? What's the estimated cost associated with that utility? And then also a copy of the RTLO, a summary that has been prepared by the county that must be provided to the tenant. Finally, one of the other required disclosures is a security deposit. Where is that money being held? What financial institution? That must be disclosed. If for some reason those funds are transferred, that must also be disclosed to the tenant. Some of the operational changes that you need to know include that 60-day non-renewal of lease notification. I mentioned it earlier in a win. It was originally 90 days. We were able to get the county to have a 60-day non-renewal of lease. There's also, if for some reason you are notified that a tenant suspects bed bugs, you must respond within a specific period of time. And then if there is a change of ownership or management, that must be disclosed to the tenant. Many of you have already been likely providing this, but there is a specific heat requirement from the county, September 15th through June 1st of each year. There's a certain temperature that you must maintain in buildings. All right, so with the resources, I've talked about the IR guidance document. This roundtable discussion, it will be recorded and it will be available under the legal videos section of the IR website. So again, recorded, that IR guidance document that is password protected. I did include the link of the summary provided by the county. So you're welcome to use the resources available on that site. And as always, as Betsy would say, consult with an attorney. So now that we've gone through the high level discussion, I'm going to stop sharing my stop sharing my slides, and we'll get into the roundtable discussion. So I have two participants here. Matt Rentschler is the legal perspective and Chris Pezza is the practitioner perspective. So I'm going to start with Matt. In the slides, I talked about briefly the operational changes. Do you want to speak about the non-renewal lease provision?
Yeah, so the magic that you indicated in your overview, the magic number for renewals or non-renewals is 60 days. And as you stated, a lot of current leases may have 30-day renewals. So for a landlord who wants to renew with a tenant, you cannot require that tenant to renew more than 60 days in advance. So you can't go to them, 3 months ahead of time and say, hey, if you want to renew, you have to do it now. If you violate that, the potential penalty is 1 month rent or damages, whichever is greater. So it's at least 1 month's rent that you could be on the hook for if you violate that provision and you try to get your tenant to force them to renew more than 60 days before the termination date. The flip side of that is if you wanted to terminate the lease, you have to give the tenant at least 60 days notice that you want to terminate. And this is important to comply with for the provisions, for the potential penalty provisions, because the way it's phrased in the ordinance is if you violate that, the tenant can remain on the property for 120 days after they receive the notice. So if you give them notice on, day 55, and your termination date is 55 days after that, well, your tenant has a right, if they wish, to stay in that property for 120 days after that. That's even if it's a month to month, And even if your termination date is within that window, it can be extended beyond that based on this ordinance. And then the month-to-month provision is important too, because like you said, most month-to-month leases, it's 30 days. 30 days notice. Well, this means it's 60 days. So if you want to terminate a month-to-month, that tenant's going to be there. It has to be at least 2 months that you give them notice for that. So, and in terms of you mentioned the effective date, and you mentioned Betsy's probable advice of speak to your attorney. This is one of those provisions where if you have an existing lease that expires this fall, and you have a provision in there like a 30-day notice and on a month-to-month lease, make sure to review this provision with your attorney, with your counsel, because when you talk about effective dates and an existing contract that affects in a city ordinance that affects that contract, one of the big questions is when they say, well, can the ordinance apply to existing contracts? One of the questions a court may ask is, well, how much does it actually affect the overall contract? Well, in my mind, it's just my opinion. If I have a lease that says I can give you 30 days notice and an ordinance that says, well, you have to give them 60 or else it extends out potentially 4 more months beyond your expected termination date, to me, that's a substantial change of the contract. So that's the effective date question throughout all of this is kind of the magic question for existing leases. And that provision itself is kind of an important one that you'll want to review with your counsel in terms of your specific lease and what your timelines are going to be.
Okay. Thank you, Matt. Now, Chris, this question is for you. You've worked under Chicago's RLTO for your entire career in property management. What are some of the most challenging aspects from a practitioner point of view?
Good morning, Adrian. Thanks for the question. Before I answer that, I just want to throw in a little tidbit that it's nice to know that free markets do work, and the bad landlord up in Glenview, lost their property even without having onerous ordinance on them. So free markets do tend to work, and the bad guys get pushed out of the market naturally. So the CRLTO, was put in place just like this one with good intentions to protect good tenants from bad landlords. And I'm going to quote my old friend Brian Bernardoni here. The hardest part about working under the CRLTO is not following the rules necessarily. It's that tenants take what was intended to be a shield and spin it on you and try to use it as a sword. And what happens is, you're doing everything you can to have a repair done. Let's say it's, winter of 2020 going into 2021, and we've got tons of snow and ice damming and roof leaks. And it's so cold out and roofers are so backed up and it's COVID. And we're doing everything we can to repair that roof. And tenants are, blasting you with, I know my rights under the CRLTO, you're not doing your job. I'm not paying rent. I'm giving you abandonment notices. I'm suing you. That's not what this was intended to do. If you are out there trying to get roofers out, trying to thaw ice, trying to repair these leaks, doing everything you can possibly do as a human being, there are line items in the RLTO which give tenants the ability to do things that are somewhat unreasonable no matter how hard you're trying. So that's really the hardest part of working with this, is tenants understanding that you can only do so much, attorneys understanding you can only do so much. And until you get in front of the judge, you just never know how somebody is going to rule. Did you do everything that you could? Are you doing everything you can under the CRLTO? So it's not necessarily a specific item about a line item in the CRLTO. It's more just kind of how it plays out and how tenants and tenants' rights attorneys, use that to come after landlords, even if you're trying very hard to be a good landlord. It's the unintended consequence of the CRLTO, if that makes sense.
Yes, it does. Yeah, I'm going to kick this over to Matt, but we want to see from just an operational standpoint, what do realtors need to know about collecting security deposits?
A lot of new things. Some of the traditional tests in terms of what you can use a security deposit to pay for, I don't think has changed a whole lot. There's the normal rule of, if there's damage to the property, it has to be a, normal wear and tear. You can't necessarily pay for that, but above and beyond that, there are disclosure requirements in terms of what you're paying it for, using the security deposit to pay for, but you have to notify within 30 days in writing of what the damage to the property is and notify them of the, if you actually paid what you paid for. A lot of that is, I think a lot of landlords typically do that already throughout the state. The biggest change is the amount that you can collect on security deposits. This caps security deposits at 1.5 times a monthly rent. But it's not just that. It's when the tenant moves in, the tenant can only be required to submit 1 month's rent at move-in. The remaining amount of security deposit, if they choose to, they can pay the rest of it off over 6 months. So if you have a $1,000 security deposit or a month's rent, you can potentially pay $1,500 security deposit, but you can only require $1,000 up front, and the remaining $500 can be paid off in equal monthly payments over 6 months. So that's a significant change in terms of, what the landlord has to evaluate in terms of whether they want to accept a security deposit. And if they do, they're limited on how much they can collect and the timelines in when they can collect it.
So I think that,
what's that?
Oh, go ahead. I'll let you finish your thought.
No,
go ahead.
The other big change, as you mentioned earlier, is when you collect a security deposit, you have to put it in its own bank account, essentially. It can't be commingled with any other assets. And a kind of one specific provision of this to make sure for most people, this won't apply. For some people, if you live close to Indiana or Wisconsin, it might apply, is that the bank that you put the security deposit in has to be in the state of Illinois. And like I said, for most people on here, that may not be a big deal, but some of you may have accounts in banks, across the border, one way or the other. So you want to make sure if that's true, that you locate a bank in the state of Illinois to comply with this ordinance.
So Matt, I think that speaks to what Chris was just saying, that there is this desire, to protect the tenant, but, there are those operational things that can, trip up the housing provider. So, you talked about security deposits, but what about move-in fees? And what do members need to know about move-in fees?
So, and maybe Chris can speak to how this worked in Chicago in terms of at least what the claim was in terms of, if you can only charge a certain amount of security deposit, but then you start applying it was quote unquote move-in fees, and the claim was some landlords were charging, excess of, they weren't actually fees for the move-in, but they were just shifting fees around. That's a claim. I'm not saying that was the case, but that supposedly was the claim. So this specifically defines what a move-in fee is. And I say it specifically defines, it's kind of a broad definition, but the basic way to look at it is if you charge a move-in fee, you have to be able to show and prove that it's actually related to the cost of moving the tenant in. So the basic things like changing over security alarms, changing over trash deposits, things like that. Or if there is some other fee you want to charge, like it says, the definition says including but not limited to additional security costs or additional trash removal. Well, it's but not limited to that you may have some wiggle room, but you want to make sure it's actually related to the typical move-in to the transition from the tenant into your apartment that the landlord has to pay for. So just make sure you can show that, make sure you can prove it. And again, review with your counsel to see if you can fit that fee into that definition.
Okay. And so, Matt, you kind of talked a little bit about that how does this operate in Chicago? And so with Chris, what is the most challenging aspect as a practitioner to operate under the RLTO in Chicago?
Well, before I answer that, I want to speak about the security deposit cap. And again, we always look at the unintended consequences of these ordinances. And, as realtors and landlords and good people, we are always looking for ways to create more affordable housing and to get more people into housing. And my fear is that in practice, this security deposit limit is actually going to keep people out of housing. And the reason I say that is a lot of times people with lower credit will offer to pay a higher deposit as collateral for the landlord to take a bet on them. Well, now the landlord cannot do that, cannot mitigate that risk. So if they have lower credit below that threshold, that landlord is going to be more inclined to just deny them. So now what we're doing is actually limiting housing potentially for lower credit people. So again, it could be an unintended consequence that was not thought through here. Hopefully that's not the case, because we do want to put more people in homes, but it's just something we're going to have to see how it plays out, as this ordinance rolls out and is put into action. Getting back to your question, and I believe you meant to ask me how the county ordinance is going to be challenging. I think the most challenging thing here is going to be that notice provision. Basically we can't give more than 60 days notice to move out, but we also can't give less than 60 days notice to move out, is kind of how this plays out. So basically the way it reads is everything has to happen in a day, which is not feasible, right? So I saw some questions from Gregory Halpern. I think I hopefully said that name right. I can't give legal advice. I'm not an attorney, but as a practitioner, I think that's how I'm going to do this, is send out the notice before 60 days, but make it very clear, you do not have to answer until the 60th day, because I don't see any other way to do this and be within the parameters of the law and still have enough time to market my unit and give that person notice if I need to get them out. So it's very tricky language to navigate. We are going to have to speak with our attorneys on that. And when I say attorney, it's one, I do want to caveat that I have an attorney for everything. There's attorneys for transactions, there's attorneys for slip and fall cases. Make sure you're speaking to a landlord's rights attorney that knows this ordinance. Don't just ask your transactional attorney for advice on this. Make sure you're talking to the right person. But for me, that notice stuff is probably the most tricky language in here, because the math on it is, not very clear. Well, it's almost too clear, I guess I should say.
Yeah, and I would just reiterate, is like you said, the 60, like I said, the 60 day is kind of like this magic date in this, but you have to know what you want to do before then, because what you want to do, it depends on whether you have to give more than 60 days or less than 60 days notice. So if you're unsure 70 days before that's going to be a problem on, what notice requirements you have to comply with. And again, some of the biggest things, and it's not just the ordinance, it's not just the timeline. Some of the penalties throughout this can be pretty harsh on the landlords if the tenant claims that you violated it. And even if you didn't, even if you're right and the tenant brings a claim, more often than not throughout this, a landlord can't recoup attorney's fees. So you mentioned attorneys, keep that in mind as well in your analysis on how you're going to approach this ordinance. I recommend speaking to an attorney ahead of time, because it may cost you a little upfront, but it may save you a lot down the road. Knowing full well, based on your lease, based on where you're located, what requirements and what hoops you have to jump through.
Okay, so Chris already talked a little bit about this, but I would imagine that speaking with an attorney is pretty key here. But Chris, how do you continuously mitigate the risk for each client and tenant?
We're doing it right now. I come on webinars like this. I learn from others in the industry. I'm always talking to my attorneys. There's, Coffee with the Gads, a great program put on by the Chicago Realtors, where, Adrian and Chris and all these brilliant people create an open forum for us to share what we're seeing in the marketplace and experiences that we've had, and our interactions with legislators and judges and sheriffs and everyone else that's sort of in the process when it comes to evictions and notices and everything else. So I'm always, reading articles. I'm always, joining these events and programs. And then there are property management courses. I don't know if I can give a plug for the one that I teach here. I'll refrain from doing that, but there are many of them out there, that people can take. And those instructors are always, making sure that what we're teaching is in line with the most current ordinance. So there are a lot of options out there that the Illinois Realtors and, the local branches, Main Street, NASBAR, CAR, and others all offer. So definitely always be checking those websites and those newsletters and staying engaged.
Yeah, so thank you for that plug on the Coffee with Your Gad, Chris. I can really appreciate that. And you said another thing with the continuing education courses. I think that in some cases this came up, which is, as a landlord and as a professional landlord, those cost money, so, and this is kind of going off, the script here a little bit, but that adds to the cost of housing. I mean, we don't have to spend a lot of time. I see you shaking your head. I'll move on. Okay. So the next question is for Matt. What is the best way for realtors to comply with the county RTLO before the June 1st effective date?
Wow. Read the ordinance, read it with, if you have an attorney, read it with your attorney, go through it. We touched on a few things here, but there's a lot more within this ordinance in terms of requirements that you have to deal with, rights that the tenant has. There are sections on rights that the landlord has, but a lot of that landlord rights section is actually more restrictions on what the landlords can do. And throughout all of this, throughout all these restrictions or these requirements, the penalties for many of these for violating these provisions are potentially severe. In many cases, it could be, and it varies depending on what provision it is, but in many cases, it could be 2 times 2 months rent plus attorney's fees. 2 times the security deposit plus attorney's fees. Those aren't small things. Especially the attorney's fees portion. And when I say attorney's fees, I'm not saying the landlord's attorney's fees, I'm saying the tenant's attorney's fees. Going in this, just assume there are some exceptions to this, but the general rule is if you have to contest this and if you have to fight this, you're going to pay somebody's attorney's fees. Sometimes both of the attorney's fees. So it's not, that's why I said earlier, it may cost a little upfront to get this reviewed, but it may save you a lot more time, money, and headaches down the road if you don't. And the biggest provision, you kind of touched on this in the beginning, is the I call the conflicts provision in the state constitution. When you're talking about ordinances, the state constitution says when a home rule county like Cook County passes an ordinance, and if that conflicts with a municipal ordinance, the municipal ordinance prevails. Well, what does that mean? Well, sometimes it's clear. The county says we support X. The municipality says we don't support X. The municipality ordinance would prevail in that. But what this is, in a way, are many ordinances within an ordinance. So your municipality may have something that covers security deposits, something that covers landlord's rights, but it doesn't cover everything else within this RTLO. So what's a conflict, and what do you have to comply with? And that's where it can get kind of confusing. And that's why the biggest advice I can give is to review this ordinance, review it with your council, review your municipal location ordinances, review all that together to make sure you know what you have to comply with. Because we know, as you indicated in the beginning, we know some municipalities either already have ordinances on the books similar to this, or they may be working towards putting something like this ordinance together, or they may try to just completely exempt themselves out. So there's no black and white, hard and fast answer to that question right now, but it's something you want to make sure that you're comfortable with going into this in terms of what you have to comply with.
Okay, so I just want to say something about the Q&A box. Matt and Chris, thank you for that discussion. We are going to open this up to some of the questions that we're getting from the audience. So Mike and Betsy have been killing it with answering questions, but there are some that they want us to ask live. So the first question, I guess this is something I might be able to tackle. Are the resources out there that can be shared that we can know or that we can use to know estimated utility costs? So that I didn't read that very well. I'm really messing this up. Are the resources out there that can be shared that we can use to know estimated utility costs? There we go. Maybe I can't answer that. I might ask you, Matt.
Well, it says, and I'm trying to think of the provision that it's referring to. I believe it says if you know the utility costs, you have to disclose what those were. And I think it's like 12 months timeline, I think, in terms of the previous 12 months. And
Yes.
if you don't know, you have to provide an estimate. And really, when you're talking about utilities, those vary from year to year. So that's kind of the problem. One of the potential issues with that provision is you can't really give an exact answer and guarantee that this is what the utility costs are going to be, because you really don't know what the weather's going to be like the next year or whether prices fluctuate. And it's kind of with that one provision in there as well, in terms of you have to keep the thermostat between certain temperatures. Me personally, I keep my thermostat in the wintertime at 65 because it saves money. But if you were similar to me before for the previous year, your cost may be more than it was the year before. And it's just kind of one of those odd provisions. So that's a roundabout way to answer, the estimate. Chris, I don't know. I would say what were your bills the previous year on that property, if you've been in that property for the previous year?
Well, some of the utility providers will actually give you an estimate. You can request that through their website. But again, it's the hardest part is that every tenant's different. You give them an estimate based on the tenant that was there for 3 years with their thermostat at 66. This person likes it at 72, and now they come yell at you and say, you lied to me. Well, it's personal preference how you want to run your thermostat. I can't control how much gas you're using. So it puts landlords in a no-win situation is what it does, but we have to do it. There are ways to do it. Ask your tenants when they're moving out what their estimates are, go to the utility providers. It's really the only ways to make that happen, and explain to the tenants, this is where the conversation really needs to happen. Explain to the tenants at lease signing or at showing that it is just an estimate. Everything's going to be different depending on how they run their heat, and the cost is really on them. So.
Yeah, and I think in the ordinance, I don't have the exact language in front of me, but I do think that it's certainly an estimate. And if they're known or if they're unknown, that has to be disclosed to the tenant. So if for some reason you haven't had a tenant in that unit in a number of months or years, and you just don't know what the utility costs are, disclose that to the tenant. I'm going to answer some of these other questions that we're receiving. This question is coming from Sharon. She is an owner of a condo unit in a fairly large building. She manages the unit on her own, but there is a management company overseeing the rules of the building, hired by the homeowners association. Now, this is a great question. Does this fall under C of 7 under exemptions? Great question, Sharon. And good luck, Matt answering that.
First, I got to find it.
So Matt, while you look for that, if I understand the question correctly, is I think what the person is asking is this an exempt unit? It is not if you are owning an individual condo as an investment. However, if you lived there within 1 year, I believe you are exempt because you lived there within 1 year. So if you lived there in 2021, rent it for 2022, and it's your only property, you are exempt, but in 2023 as a rental, it would not be. Now, as this plays out in the market, I do see HOAs that have their own rules that violate the CRLTO. And so it makes it very difficult to rent in those units. So, that's something you want to kick over to attorney, you want to raise with the HOA, because I have seen HOAs that have rental rules that are violating CRLTO. And we always raise that with those boards and tell them they need to kick that to their attorney. So it does happen in the marketplace. Look out for that. Don't be the one violating RLTO because your HOA is asking you to, hit the brakes, raise the question, do everything you need to do.
Yeah, I would agree with that. You're dealing with two different agreements between your HOA but you also, if you want to lease it out, that's your decision. But if you lease it out, you have to comply with this unless you fall within that specific exemption. So that's a decision you have to make depending on what the rules of your specific building are. So.
Okay. So the next question from Georgia. So if the owner were to own 7 units instead of 3, would the exemption also not apply? Does the law only apply to properties that are fully owned by one owner? Well, I think the exemption is 2 to 6 units, owner occupied, right?
Correct.
So
Correct.
if it's 7
If it's
units,
7, right.
then it falls outside of it.
Correct.
Okay, I'm going to move on. Does the requirement on keeping a security deposit in a separate account apply to all landlords with only one Cook County property or only a few overall?
If unless you fall within the exemption, it would apply to you. So.
Yeah, that was a pretty straightforward answer to that one.
And I wonder if it's, if you own multiple properties, the requirements on keeping the security deposit still apply to you.
Okay. So let's see what the next question is. If a lease was written and lease ends 5/31/2021, does it fall under the new ordinance regarding return of security deposit, etc., since there is a 30-day period prior to return of the deposit?
Well, the effective date on this is, that's a good question. I would say the effective date is June 1st. So if your lease ends, the requirements on that lease would be the requirements not under this because it's not the effective date. But these questions on applicability and effective date, these are the most important questions. Depending, like I said earlier, depending on which section you're dealing with, there may be arguments back and forth on what the effective date for it is, because there's an overall arching saying that the effective date of this ordinance is June 1st. But when you're talking about which provisions actually, how much do they affect the existing lease, how much do they affect the contract of it, that's a question that is a good question, and it's a largely unanswered question for some of this stuff, or it hasn't been answered in 40 years since Cook County, or I'm sorry, since Chicago put theirs in, and the interpretation of that may have changed in 40 years depending on which judges you go before. So if you're dealing with a lease that ends before the effective date, I would argue that the requirements are prior to the effective date. But your tenant may disagree and may push the issue. So that's one of the things to make sure to check with your counsel on your specific situation to make sure that you think you're on firm ground with which direction you head in terms of where you want to go with it.
So Sharon is bringing up some great questions, and they will spur a lot of debate, because as you were speaking, Matt, Betsy said that she would argue that it does not apply. So
No,
I think
that's what I was saying. Yeah.
Oh, okay.
Yeah, I think I just mumbled my words a little bit, but
Oh.
yeah, I don't think the ordinance would apply to a lease that expires before the effective date.
Okay. All right.
But I was just saying your tenant may disagree and may try to push that issue. So you want to make sure you're prepared to fight that point if you need to. So.
Got it. Okay. Okay, I was getting a text message here. I'm going to ask some more questions, but we only have about 15 minutes because we will end right at 11 a.m. So the next question we have is, since 60 days is so important, how exactly do we count the 60 days? I don't want to be one day off and incur huge fees.
That's a good question, because some references in this ordinance reference business days and others just reference days. When it says days, I would recommend going back calendar days, because the other sections within it say business days. So how do you count that? It doesn't really say that the day includes the day of notice, or the day that and that's also the magic question in terms of what does the first day count, or is day one tomorrow?
Well, and it gets more complicated than that too, if you see how this plays out in Chicago, because judges basically say you can't expect someone to move out mid-month. There's no housing available mid-month. So in Chicago, if I want to serve what we have as 30-day notices here, or what we did have until the fair notice requirements were put in, if I wanted someone out on June 30th, I technically had to have that served by May 31st, because you had to give, that full month. If I served it on the 1st, even if it was 30 calendar days, it's not considered delivered in time. That would kick out until the end of the next month, is how the judges were interpreting that. So the answer is we don't really know until this gets in front of a judge and how they interpret the letter of the law. So what I'm going to do, and I'm not speaking on behalf of Illinois Realtors, and I'm not an attorney, I'm going to serve it the same way. If I need someone out in 60 days, I'm going to look at that as 2 full months and, kind of handle it that way personally until told otherwise, because I don't know what else to do.
Yeah. And like I said earlier, it really complicates things when you're dealing with month-to-month leases, because typically your month-to-month leases are month-to-month for a reason, is you may not know 2 months in advance on what you want to do 2 months ahead of time. So this kind of throws a wrench into that process, but that's the way it's worded.
I can speak a little bit to why there's business days included in part of the RTLO, is because during the negotiations, we talked about how if you have to return the security deposit, or if for some reason you need to correct an error, banks aren't open on the, it's tricky. So we wanted to make sure that it was very clear for business days that landlords had 2 business days to cure it. So you subtract the weekend, that technically would give you 4 days, right? If you had to cure something. So that's why there may be some of that inconsistency, but I think what Chris said with 2 months, keep it consistent, go the full 60 days, don't assume business days, just 60 days, and keep that consistent throughout. I think that's just seems like a smart way to approach it, but I am also not an attorney. So we've got some more questions coming in. Let's see here. So there was a question about, it might have been answered live. So let's see here. There was a question about how to access the Illinois Realtors guidance document. There is, I believe that there is a link available that should be shared, but there is a link. It is password protected off of the Illinois Realtors site. You know, I'll probably hear from Matt or from Mike or Betsy about the link if that is something that is shared. So some of the other questions that we're getting. Can you have
I
one?
actually see one. I actually see one. I think it's an important question. Can you provide notices electronically? Yes, there are provisions within the notice sections. If you normally communicate with them via electronic. The thing with the electronic notice that you'll want to take note of is for like security deposit for receipts and all that. You still have to send them a receipt, and I think it calls for like an electronic signature or DocuSign or something like that. So yes, but it may be more complicated in terms of sending receipts to them unless you have a hard copy of those receipts to send them.
Okay, good. There was another question about the bank accounts. So this one, can you have one bank account for all your security deposits? Matt, you might have talked a little bit about this, or Chris, or does each tenant need their own account?
That's a good question, and every time I read that section, it wasn't really clear. That's my best answer. It says you can't commingle accounts. I don't know. Does that mean you can't commingle them with your other security deposits, or you can't commingle them with your other, business funds accounts on the side? That's definitely true. But it will create some issues. And I don't know if it's like this in Chicago, Chris, in terms of how, if there's this requirement in Chicago and how they deal with that.
In Chicago, we do it by building, so 123 Main Street has its own security deposit account separate from the operating account. 234 Center Street has its own security deposit account separate from the operating account. So not by tenant, but by building, which is still, a little onerous. And Matt, the point that you hit on earlier is really the trickiest part. If you have a Florida owner that owns a 15-unit building in Cook County, they actually have to fly to Illinois and open the account there. They can't open that account in Florida. A lot of owners forget that. So.
Yeah. And what you say makes complete sense. It's just how they worded it in here isn't crystal clear. So that's.
And Matt, Betsy may have an opinion here too. So Betsy, if you wanted to say something about the commingling of funds or just what you have to do with a security deposit.
Right. I do want to just add to that. I would think, believe me, I'm not looking at the exact language because the questions are coming in quickly. So we sure do appreciate all the questions and the chance to address them. With regard to an escrow account, as Chris said, they do it to be clean, so they do it by buildings. I think a responsible housing provider would set up an escrow type account titled as such at an Illinois FDIC insured institution. It's got to be located in Illinois. And then you have to have an appropriate record keeping accounting mechanism for that account or those accounts. Like Chris said, if you have it by building, that's fine. If you're a housing provider that has 7 buildings, as long as it's an escrow account for the benefit of the owners and the tenants, or the landlord and the tenant if you are the landlord tenant, but it cannot be subject to the reach of the housing provider's creditors. So it has to, you definitely want to set it up with the advice of your legal counsel. I'm muting myself now.
Thank you, Betsy.
No, that's definitely an important point. In a former attorney life, I was briefly a bankruptcy attorney, and that is, you want to make sure that to keep those protected in compliance with this, and to make sure that it's properly listed. You want to make sure that they're properly organized, and that the escrow idea is actually really good.
Okay, so we have about 5 minutes. I would like to ask Chris one final question, but before we do that, Chris and Matt, can you see some of the open questions? I want to give you a chance if you wanted to speak to anything? Okay, Chris, go ahead if you see something in that Q&A box.
I see a great question in here from a Deborah. Are lease renewals considered new leases under this ordinance, or do the terms of the original lease apply? Here's how I'll answer this. If you have a lease with a tenant that you previously gave them, and there's something in there that's going to violate this ordinance, and you send them, a 1-paragraph renewal that says we are renewing your lease at this rate, all the terms of your original lease apply, or we're going to roll that old lease forward, that's a slippery slope and you could be in violation. All the renewals going forward are going to need to be new leases that follow this ordinance. You can't have stuff in those new leases that violate this ordinance. So I'm sure there's going to be a lot of questions. Where do we get those leases? Stuff like that. I know internally Illinois Realtors and the local associations and everyone is discussing that. But for now, you're going to have to go to your attorneys and, make sure that at least review the lease that you're using and make sure there's nothing in there that's going to overlap with this ordinance. Late fees is going to be the number one change people are going to need to make. A lot of people in the suburbs just had set $50 late fees or a flat 5%. And then the notice periods are going to, have to be another one that are going to be, needed to review in a lot of those leases. Review everything, but those are the two that are going to pop to the top of my head that a lot of old leases are probably going to be in violation of.
Yeah, no, it's a great question. And it's one that we internally discussed here in terms of the effective date and the application to existing contract or existing leases, which are contracts. But our general advice, and again, is to meet with your attorney ahead of time. Before that, review it with your attorney, review your municipality on what may apply, what may not apply. And if it's a renewal, from my perspective, I kind of look at a renewal as it's a new contract with the same terms. In terms of this, that's the safe way to approach this. Now, again, check with your own counsel, and if you look at it that way, a way to do it is to, like Chris kind of said, you renew your current lease, but perhaps with addendums to put it in compliance with this ordinance if certain sections of your existing lease aren't in compliance with this ordinance. But yes, it's a very good question, and it's kind of one of those open questions in terms of the effective date and the applicability, big word, to existing leases. But from a attorney perspective, on the play it safe side, I would treat a renewal as a new lease, a new contract. But the biggest advice is just to check with your own counsel in terms of what your current lease is and how much it's either in compliance or not in compliance with this ordinance going forward.
Okay, I do want to make a quick statement because there was some questions about the lease. There is a suburban group of brokers and lawyers that are working on a lease. So it's in the works. Stay tuned for that. The last question that I would like to ask Chris is, how do you maintain healthy relationships with tenants? Let's end on a high note.
Absolutely. And that's a great question. And really, it's how do you maintain a healthy relationship with anyone, right? Be honest, communicate, and be kind. We got through a very tough period in COVID, working with lots of tenants that were going through a lot of different issues with clear communication and kindness and compassion. Now, at the end of the day, this is an income-driven business. There is a bottom line we have to take into account. But if you communicate with tenants and you let them know what's going on, you may be, and there's tricky stuff in here about 72 hours for repairs. If I've got an old magic pack for a heating system, that part might be 2 weeks out. If I just don't communicate with that tenant for 2 weeks, they're going to be very upset. But if I establish the groundwork right away that, hey, this is out of my control, there's this part, it's in another country, it needs to be shipped here, then installed, it's going to take a while. What can I do for you in the meantime? Can I get you space heaters? All that good stuff. you're going to set that tenant's expectations better. They're not going to be as upset. They're going to understand it wasn't you as the landlord who came into their apartment and smashed their furnace with a hammer. It's just something that happened and it's beyond our control, and we're doing everything that we can. So it all comes down to that communication and just being kind and understanding at the end of the day, your tenants are people just like you that want to come home to a place where they have no problems. They had a hard day of work and they just want to relax when they get home, just like you. So treat them that way, you know, and be respectful and be communicative. And hopefully, if tenants and landlords have good relationships, you know, this stuff doesn't spiral out of control, and then we don't need even more onerous ordinance. We can just deal with it as people, you know.
I love that statement. I love it. That is just an awesome way to end this session. Matt, I want to say thank you to you for participating. Chris, thank you again so much for preparing and for your time today. Betsy and Mike, thank you for responding so diligently to all the questions that we received. Since it is 11 a.m., actually it's 11:01, we're going to end today, but thank you again for attending, and certainly more to come on the RTLO.
Thanks.
Thank you, everyone.